to be talking today about the case Crown v. Kitas, which was tried in a Virginia Circuit Court in 1992. A plaintiff student filed suit against the defendants, the Red Hot Chili Peppers, hence the song Californication playing at the beginning of this presentation, their agent, Commonwealth and University, for damages arising from alleged sexual assault and battery by the Red Hot Chili Peppers band members after a concert held at George Mason University that the student helped to organize. The student filed a motion for judgment to which the agent responded with a demur. Here's an overview of the presentation. I'll begin with the facts, then I'll discuss the issue of bar, then the decision of the court and the rule of law, and finally the disposition of the case. The facts are as follows. While the plaintiff and another student member of the program board of George Mason University sat waiting outside the band members' room after the concert on April 21st, 1989, Kitas and the other band members approached them, and Kitas pulled down his pants, thrust his penis into the plaintiff's face, poking her in the cheek. The plaintiff claims that Kitas assaulted and battered her, intentionally, unlawfully, violently, and without her consent, and that the other band members aided and abetted in the assault and battery. Count 1 of the motion for judgment also claims that the 4 band members went to the plaintiff's car, knocked her to the ground, and took her keys without her consent. The plaintiff seeks consequential damages of $1 million in count 1 from defendants Kitas, Frusciante, Smith, and Balzeri, which are the Red Hot Chili Peppers band members. Count 2 claims $1 million in consequential damages from the defendants Lindy Goetz, LG Management, and Variety Artists International. Count 3 of the motion for judgment contends that the defendants, Commonwealth of Virginia and George Mason University, owed a duty to the students of public universities in Virginia to protect them from the acts of persons brought onto campus and to ensure that the activities of campus-sponsored organizations do not expose the student body to unnecessary and foreseeable risk. The plaintiff claims that the Commonwealth and George Mason University knew or should have known that the band members had acted in a violent and sexually abusive manner in the past and after previous concerts. She also claims that as a direct result of the breach of duty by the Commonwealth and George Mason University, the plaintiff sustained injuries from the band members. In this count, the plaintiff seeks consequential damages of $1 million. The plaintiff also seeks punitive damages from every defendant of $1 million. Now I'm going to discuss the issue at bar. A few definitions are helpful. First, tort. Tort is a wrongful act of an infringement of a right other than under contract leading to civil legal liability. Next, respondeat superior, a doctrine that a party is responsible for or has vicarious liability for acts of their agents. Finally, demur, an objection that an opponent's point is irrelevant or invalid while granting the factual basis of the point. So the issue at bar in this case is the plaintiff sued for consequential damages against the Red Hot Chili Peppers band members, but also their management company, because she contends that these defendants knew or should have known that the band members had acted in a violent and sexually abusive manner in the past and after previous concerts, and that the assault and battery as described in one of the motion for judgment were likely to occur. The plaintiff claims that these defendants owed a duty to the plaintiff not to expose her to the likelihood of such assault, and that as a result of the breach of that duty, the band members injured the plaintiff. The plaintiff argues that the band members and the management company stood in a master-servant relationship to one another, and the management company was responsible to prevent the band members from committing these acts. And she also says that the band members and the management company had a special relationship which made the management company responsible or liable for the band members, and she and the management company, or Lindy, also had a special relationship. The court disagreed with this and disagreed that the management company was the master in the master-servant relationship. The court thought that the band members were the master, if anything, and the management company was the servant, and so that did not add up to our argument. The special relationship was not found either by the court. Now I'm going to discuss the decision of the court and the rule of law. Judge Thomas A. Forecourt decided to sustain the demur. In other words, he decided that the agents or the management company of the Red Chili Peppers cannot be held responsible for the acts of the Red Hot Chili Peppers because they do not serve as an example of the master-servant relationship. In reality, the agent would be more of the servant and the Red Hot Chili Peppers would be more of the master. This rule of law was based upon Marshall v. Winston, which protects another from their criminal acts or intentional acts of third parties. Another case, Fox v. Custis, found that a probation officer and a parole officer did not have a special relationship with a parolee who committed numerous torts in violation of his parole. Third and last, Klingberg Management Group Company v. Vito found that no special relationship existed between the landlord and tenant, which would give rise to the landlord's duty to protect the tenant from the intentional torts of third parties. Lastly, I'll discuss the disposition of the case. The court ruled that the plaintiff may amend the cause of action against Lindy Goetz and LG Management within 21 days of April 22, 1992. So the court remanded the case, and that's where this case. Lastly, I'll discuss the disposition of the case. The court ruled that the plaintiff may amend the cause of action against Lindy Goetz and LG Management within 21 days of April 22, 1992. So the court remanded the case, and that's where this case ended. The information of what happened after this case is not readily available or public information, so this is where I'm going to end this PowerPoint today. Thank you all for your time, and I'm looking forward to hearing about your case as well.